All right. Hello, Nevada. My name is Francine Engel, and I am from the state of Maryland. And I'm a political scientist, and I work in the field of American constitutional development. And I am currently doing work for the Maryland Council for Civic and History Education.
Hello, my name is Jocelyn Broman. I am an alumni of the We the People program. I competed back in 2006 at Nationals, which feels like several lifetimes ago. I am also an attorney, and I currently work on Capitol Hill for Representative Don Young of Alaska.
All right. My name is Evan Gessner. I'm a civil rights attorney in Lexington, South Carolina. This is my first year judging We the People at the national level, though I've judged the state competition here for probably about 12 years or so. So I'm very excited to be here, and I look forward to your presentation.
All right, if you can introduce yourselves, please.
It's awesome to meet you all. My name is Conrad Drews. I plan on attending University of Nevada, Reno for political science. And outside of We the People, I participate in our robotics club and tennis team.
Good afternoon, judges. My name is Laura Flynn. I plan to study psychology in the fall at University of Nevada, Reno. And in addition to We the People, I'm the captain of my soccer and softball team and an officer for the National Honor Society.
Hi, my name is Nicholas Pizza. In the fall, I plan to study finance and economics. And in addition to We the People, I'm in National Honor Society and the captain of the cross country and track and field team. And we're here with our coaches and teachers, Milton Himes, Ryan Spisman, Ashley Nickel, and Sean McClelland.
All right, wonderful. All right, so I will go ahead and read the question. So this is a quote from Oliver Wendell Holmes. It says, quote, "I do not think the United States would come to an end if we lost our power to declare an act of Congress void. I do think the Union would be imperiled if we could not make that declaration as to the laws of the several states." End quote. What impact has judicial review had on federalism? Is judicial review a counter-majoritarian practice? Please support your position. And what limits, if any, would you place on the practice of judicial review? And you may begin whenever you're ready.
Alexander Hamilton argued in Federalist 78 that the complete independence of the courts of justice is essential in a limited constitution and must declare all acts contrary to the manifest tenor of the Constitution void.
The Supreme Court grants cert to less than 2% of cases appealed, which promotes state resolution of most constitutional issues. We agree with George Mason law professor Elia Soman that judicial review has both promoted federal supremacy and state autonomy at different points in history, but overall has favored the increasing power of the federal government through the court's use of the Commerce Clause and the Supremacy Clause.
Judicial review is the Supreme Court's ability to declare an act of Congress unconstitutional as established in Marbury v. Madison, an order of the executive as an ex parte merryman, and acts of states void as shown in Martin v. Hunter-Lessie.
Initially, in McCauley v. Maryland, the Supreme Court used judicial review to find acts of the federal government constitutional, but constrained the federal government's power in Marbury v. Madison.
The Supreme Court's enforcement of federal supremacy remained through the Civil Rights era, including Loving v. Virginia's reversal of a state law prohibiting interracial marriage. But the tide began to turn in the 1990s under Chief Justice Rehnquist. In cases such as United States v. Lopez, the Supreme Court began to use judicial review to constrain the commerce power in favor of state governments.
Judicial review is inherently a counter-majoritarian practice, but this is necessary in instances when the expedient majority opinion rooted in congressional and state laws are unconstitutional. Counter-majoritarianism is the practice of ruling against popular opinion in order to uphold the principles of the Constitution. For example, in Brown v. Board of Education, the Supreme Court contradicted the popular opinion at the time and their previous precedent set in Plessy v. Ferguson, when Chief Justice Warren wrote, "In the field of public education, the doctrine of separate but equal has no place." This decision was critical in upholding the ideals of equality within the Declaration of Independence and in the Constitution.
Similarly, in Texas v. Johnson, the Supreme Court ruled that the controversial action of flag burning was protected expression under the First Amendment. Although it was unpopular, Johnson paved the way for future protections of symbolic speech, such as wearing armbands and burning of draft cards.
The counter-majoritarian practice does not come without negative implications. Yale professor Alexander Bickel presents the counter-majoritarian difficulty, which occurs because Supreme Court justices, in accordance with Article 2, Section 2, Clause 2, are appointed by the president and confirmed by the Senate. They are not directly chosen nor representative of the people. Some argue that this practice is in fact anti-democratic and must not be fully autonomous.
Two limitations which would maintain the integrity of the judiciary would be through Justice Brandeis's 7 rules of Ashwander, specifically judicial minimalism and passive virtues. Judicial minimalism is a self-imposed regulation that advocates for saying no more than necessary to justify an outcome and leaving as much as possible undecided. The justices should also practice passive virtues, the concept that the court should encourage resolution of political disputes by the other 2 branches before accepting the case for review.
Supreme Court justices should abide by limitations proposed by Brandeis's Ashwander doctrine, but the Supreme Court is ultimately in the best position to dictate constitutionality because it is independent from the pressure of re-election that faces Congress, the executive, and state officials. This power should only be wielded when absolutely necessary in order to preserve balance among the branches. Thank you.
All right, so I want to start with your discussion of Ashwander and judicial minimalism and the whole idea of passive virtues that Brandeis brings up. So can you give me an example of when you think it would be ideal for the Supreme Court to intervene and exercise judicial review? I mean, if we want them to have the passive virtues and really only intervene when absolutely necessary, what was a case where it was absolutely necessary?
Well, in instances where there is a fundamental right at risk, or there is a minority that is being oppressed under the law, this is when the Supreme Court definitely needs to practice judicial review. We can see this in cases such as Loving v. Virginia and Brown v. Board of Education, where minorities and races were being discriminated against, and they needed to uphold the principles of equal protection under the 14th Amendment.
Another example would be in Wisconsin v. Yoder, when the Supreme Court stepped in to protect the Amish's long-standing faith.
I agree. Former House of Representatives member Diane Watson once said that the Supreme Court has often been the sole proprietor of minority rights in the face of majority tyranny.
So what do we do with Korematsu?
I believe that Korematsu v. United States is an instance where the Supreme Court actually got the ruling wrong. They ruled that Franklin Delano Roosevelt executive order for Japanese internment was in fact constitutional, and it did not abide, or it didn't violate the 14th Amendment Equal Protection Clause. And in this instance, we can see that sometimes the Supreme Court is wrong and they wield too much power in certain circumstances.
I agree. Another time when the Supreme Court got it wrong is in Citizens United v. Federal Election Committee. They ruled that corporations made up of people have freedom of speech under the First Amendment. According to Open Secrets, the past election cost upwards of $14 billion. This makes the politicians we elect representative not the people, but the corporations that give them this immense money.
Okay.
So how do different theories of constitutional interpretation influence judicial review?
Well, a strict construction of the Constitution means that the justices refer to the original meaning of the Constitution written by the Founding Fathers, and this is most associated with judicial restraint or judicial minimalism. And on the other hand, we have a broad construction, which is also referred as living constitutionalism, which also coins the term of judicial activism. And in my opinion, judicial activism and living constitutionalism is the best way to interpret the Constitution, because we change so dramatically over the years and generations that we also have to adapt with the Constitution in that regard.
I agree. Thomas Jefferson once called the Constitution a ball of wax ready to be molded by the Supreme Court.
Okay.
So
But
I
if,
go ahead.
sorry, go ahead, Francine.
Yeah, I was just going to ask, so, you're talking a lot about judicial restraint, which is excellent, and contrasting that with judicial activism. Some people have this understanding that judicial restraint is a conservative decision and judicial activism is a liberal decision. But I think that's really not the most sophisticated understanding of things, because I think we've had situations where we've had activist conservative courts and we've had activist liberal courts. Can you give me an example of what you would consider an activist decision, perhaps where the court's going beyond their powers and exercising judicial review, something that's conservative and something that's liberal?
On the liberal perspective, Roe v. Wade was absolutely exercising judicial activism, as it set a decision not in line with the Constitution, but one in line with values to one party.
All right, and what specifically is it with Roe versus Wade that we would classify it as judicial activism? Not saying you're wrong, I just want you to develop it more.
It's that they enacted a limit based off of when or how long the woman had been pregnant for, which was judicial activism because it was considering the societal impact and not only just the constitutional law behind it.
Okay.
I'd also like to bring up the point that Roe v. Wade was also acting on the precedent of Griswold v. Connecticut, which ruled that the Fourth Amendment and the Ninth Amendment protects the right to privacy. And in that case, it involves contraceptives and the right to reproductive rights. So Roe v. Wade, although it is considered activist, was acting on previous precedents, which abides by the idea of stare decisis, where we let the previous rulings stand and work off those instead of just making new ones.
A conservative example would be Dred Scott v. Sanford, when the Supreme Court first ruled that because of Dred Scott's status as not being a citizen, it couldn't be accepted into the court, and then continued to rule a decision and ruled that the Missouri Compromise was unconstitutional.
Well, let me ask, would any of you think of Brown versus Board of Education as an activist kind of case?
I would say it would definitely be considered activist because it completely overturned the precedent set in Plessy v. Ferguson, and judicial restraint advocates for following previous precedents, but in this case, it was extremely necessary that the Supreme Court stepped in because a fundamental right was at risk.
I would disagree. I don't believe it was an activist decision. I think people merely say that because it went against the whims of the people at the time and it was counter-majoritarianism. They're merely following the Constitution and saying that all men were created equal and that we can't have these separate institutions.
Sure. Now, when we talk about whether it's an activist or not, are you looking at the result, or are you thinking more about the process? What was the court's rationale? What are they looking at? How do you determine whether you're looking at an activist decision or something else?
One way to determine that is look how quickly it came from the district court to the Supreme Court. And in Brown v. Board of Education, it went very quickly and more quickly than most cases have in the past.
I would also look at the process of them reviewing the case. If they're looking at previous precedents and rulings from past courts, then I would say they are practicing more of the Ashwander doctrine. But if they are acting more on their opinions or the whim, then it could be considered judicial activism.
Let's talk real quick about what limits Congress should place on the judiciary. Oh, come on, John. Not allowed.
I had to do it to you. I'm sorry. Great. Let's recognize the students for outstanding hard work and participation today.
Great job, guys.
Yeah, you really did a fabulous job, and I have to tell you, bringing up the Ashwander doctrine, I was really kind of blown away, because first, you don't expect that in high school. You don't really get that in like an undergraduate class, or even a graduate or law school class where people are really that familiar with that. So I was really impressed that you brought that up. And your discussion of judicial restraint and judicial activism was really anchored very well in constitutional theory that we have out there. So that was really well done. I was really impressed with how you did that, and I really liked when you were answering your questions. You all sort of complemented and added on to each other, and where one kind of left off, you brought up a counter position, even if it wasn't necessarily your real position, but you brought out that other side. So I was really happy that we got sort of a full discussion of both sides of issues that were brought up. So I thought you did a really, really nice job with that. Congratulations.
Yeah, you all did a great job. I wish we had had more time, because I was going to ask you, because the only limitations you were putting on judicial review is on the judicial branch had to do it on their own. So, I mean, what happens when they're like, nah, we don't want to do that anymore? Which is where this kind of discussion of judicial activism and judicial restraint like kind of really takes off, because judicial activism and judicial restraint are viewed very differently depending upon who you talk to and depending upon like political ideology and all of that. We didn't even get to the partisan confirmation process. Ugh. We need more time. But anyways, but you guys did a great job of doing that discussion. And when I'm asking like, what about Korematsu? Because that's like the real point. Like if you're talking about the court is only there to protect minorities, then you've got at least one case. It's just like, this does not make any sense in this 20th century time period that we're talking about. So you guys handled that very well. And it's like, obviously the court made a mistake, and that the court can make mistakes is probably one of the reasons why that might be an argument against that counter-majoritarian inherency, because they can make mistakes. So, but anyways, it was a great discussion, and I would have loved to go a little bit deeper, but you guys did a great job and provided great examples on how, whenever you were giving your arguments. So great job.
Everyone, great job. One thing I was kind of expecting at least one of you to say about Korematsu is to say, well, hey, it was war. We can expect that. And from the gist of your answers, I got the feeling that it didn't matter. Right is right and wrong is wrong. And while a lot of people thought, well, there's a war going on, we need to do these things, it doesn't make it right. And I think we should expect that from the court. So I think overwhelmingly a lot of people do look at that case as a major failing of the court. One thing, going back to Brown versus Board of Education, I remember talking about this case, I believe it was even in college before I went to law school. And my colleagues correct me if I'm wrong, but as I recall, Brown was unique in that the court was looking at things they hadn't looked at before. They didn't just look at the statutes and look at the law and say, well, it says they can do it, so they did it. But really looked at how Plessy versus Ferguson, and separate but supposedly equal, was having such a negative impact on people, and really looked at essentially data, the social sciences data that came about, and then showed what a horrific impact segregation was having, and just looked at that and said, okay, no, this is inherently not equal. And so that was a huge change, as I understand it, with the court. And so maybe that's where you might call that activism. I might call it activism. I don't think it's wrong, but that's a very big difference from just looking at the black letter of the law and saying either it's within this or it's not. Again, everyone, great job. These are not easy concepts to master, especially when you're in high school. So great job.
Yeah, fabulous
Thank-
job.
Thank you so much.
great job.
Yeah, thank you all so much.
Congratulations again.
Thank